grounds for removal of the leader of opposition, and I hope you addressed your mind, page 3. I hope you address your mind to the act which is supposed to be amended, particularly the ground therein. And if you have addressed your mind to that act, I would want you to tell me how incompetence as a ground is going to be determined and how clear it is, how misbehavior as a ground is clearer and how it is going to be determined, and inability to perform. I would want you to look at the duties of the leader of opposition under section 6A of the Act, and then tell me how those duties, unless others are added, one can be seen to have been unable to perform, and how that is going to work. 2, you've yes made the case for advantages and disadvantages, but you've also not addressed us on how you propose, if a meeting is to be held by all the opposition political parties, to choose head of opposition, who convenes that meeting, how, where, and the quorum, among others. Lastly, from me, though your paper is elaborate on all aspects, you've shied away from pronouncing yourself on the bill as such. What is the position of LDC on this bill after your analysis? The conclusion, in my view, leaves a lot to be desired. I want the final position as lawyers.
And the LDC has noted Tanzania is not working on the same lane with democracy of multi-party politics. And at least Kenya, it's their emphasis. I think, Chair, we need to address our mind on that. And as we may think and agree, so we need to move an extra mile also to see how best Kenya has been able to do so. And vis-a-vis the Tanzania, even I wish even to ask our guests, in your research, because now we are looking, at least these countries which are like British colonies, do you have any other country where you can just give us your view in time? Or at least there was either other colony apart from British, and we get at least analysis as regards to this political liberty as we are moving to this. But for me, even I may conclude that you have already given your conclusion and the position. If time allows, maybe we shall share on that. Thank you.
Document or presentation coming from the Law Development Center. First, as your name suggests, you must develop laws and not make proposals that regress our laws. So from that angle, I would like to ask you the following questions. When on page 2, under bullet 1, increase democratic participation, you go ahead and say the reform addresses concerns about dominance by a single party and ensure that smaller parties within the opposition have a say in the decisions. And when you go down, you talk about marginalization and etc. What is it that in Parliament, under the leadership of the opposition, you feel that the other parties are marginalized from? Is it resources? Is it positions? Or the way Parliament conducts itself does not give the smaller parties platform to raise their issues? Closely related, I want you to address us, because the bill proposes that all members of Parliament from the opposition elects the leader of the opposition. I'll give an example that is closely related to us. I am a member of Parliament from UPC, and we have members of Parliament from UPC who sit on both sides of the House. How would such a member, who has already shown their loyalty to the government, the majority, but retains the right as a member of Parliament from the opposition? And you are aware also some arrangements by, I think, the Democratic Party, those two. So, how do you address that concern that members of Parliament of the opposition, who now sit on the side of government, retains the voting right in electing a leader of the opposition, yet their loyalty is now with the sitting government? Thirdly, when, and it's closely to what Honorable Niwaga raises, when you say you must consult, what happens if the party does not consult? I know you also raise it, but what happens if the party does not consult and goes ahead to make their nominees? On the grounds that are proposed, incompetence, misbehavior, and inability to perform their duties, from whose lenses? Is it from the lens, for example, the National Unity Platform has appointed, nominated their leader of opposition, and they are happy that the leader of the opposition is competent according to them, is behaving well according to them, and is performing the duties very well. So in whose lenses now must that leader of opposition be judged to be incompetent? Honorable Fox here may not be happy being a member of Parliament and says this one is incompetent. So do you see the confusion that is likely to arise by that, because somebody else may say you are incompetent? The example you gave of Kenya, and I have looked, and I will summarize, the standing order number 20 of Kenya. This is what it says. It says the second largest party, which is the largest opposition party, is the one to elect the leader of minority, except where there is a coalition. That's when they are required to consult, which is exactly what we have in our current Administration of Parliaments Act, which says the largest party may consult. Meaning, if there is a formal arrangement between NUP and NUP are signed with the UPC, because there are even members of UPC, of DP, who opposes NUP on the floor of Parliament, because there is no binding agreement. But where there is a binding agreement, that's where now NUP will be required, because you have signed an agreement that in your government, in Parliament, you are going to give us 1 or 2 positions. So the situation in Kenya, in my opinion, is actually quite different, because it's contingent upon a pre-negotiated coalition agreement. We are going to work with you, you'll give us 3 ministers, and this. So when I'm forming government, or even the shadow government like that, I am under obligation to then consult you, because we have an agreement. In Uganda's case, it is not. Our coalition agreements are just informal, in the night. People go to maybe State House or Chadondo to meet folks, and the rest. Nobody even knows where such agreement exists, except people who are moving with it in their mind. So I respectfully then depart from the use of the benchmark of Kenya, because we seem to be at different democratic practices. Lastly, it is my opinion and the opinion of many others that this bill is brought in bad faith, and it doesn't even solve any problem at all. When you read the Act as it is, the Administration of Parliament Act as it is, and how it provides for appointment of members of shadow cabinet, yes, it is in consultation. And that's what has been happening. I'm a shadow minister for justice, but my party was consulted before I came. I know also a member of, I think, DP, who is in the shadow cabinet. And that's so if you analyze what we have been implementing, you find that there is no exceptional circumstances that require that the law should be amended, which is also what you alluded to, that you have failed to clearly see from the bill what exactly the mover is trying to clarify. So I thank you.
The ruling government, actually it's not at night, I want to clarify, they have MOUs which are clear read. So in my thinking, are they still in opposition? When you have MOUs and you are here in your, so I even don't know whether Oduri is in the right position to make, because these MOUs are there and they are properly written and people are seen sharing cabinet positions within that. So in that aspect, look at it. People who have MOUs, which are clear and understood, where do you categorize such kind of people? Secondly,
just for my benefit, could you confirm the existence of them? Which parties? Just since you seem to know.
You have said there are people who are sitting this way and that.
That's why I mentioned at night is an informal arrangement. But for you are changing the position and you said there are documents. So if there are documents, can you confirm?
But they are serving. You have UPC people serving in government, in cabinet, and they are still remained as there. But anyway, the second one is these people have different manifestos. They are different governments within themselves. How do you look at them in terms of harmonizing? At what stage are they going to harmonize their manifestos?
Thank you, colleagues. Behavior, inability to perform, the concern of how do you prove and how do you tell. We have highlighted a few that we may have. One of the negative aspects of the bill, we have highlighted that this is something that can cause challenges in terms of proof and whether somebody is being witch hunted or is really incompetent. Who determines that? Is it the party to determine that brought him? Is it all the opposition party? And how do we harmonize that in view of, again, the concerns we're raising, where we're having opposition party members also working with the ruling government? I think that is going to be something very hard. No. They're actually ambiguous because they cannot be easily proved. They cannot. Thank you. Yes. Yes, thank you on that area. We shall amend accordingly. Then on the convener,
Mr. Mkivi, does incompetence? It does. Now, if incompetence exists, I think the question would be who determines that incompetence. Because incompetence, as a matter of fact, exists. There are people who are clearly incompetent. So the issue here would be who then determines. Is it in the eyes of the entire parliament, or is it in the eyes of the opposition MPs, or the party with the strength, with the greatest strength?
yeah,
It's a constitutional office. The leader of opposition is not property of the opposition. We fund, as a nation, the leader of opposition. So it's our mandate to determine whether or not they are incompetent, all of us as a parliament. I thought that would also be a foregone conclusion.
and that's where that area, it is not rich on how do we determine these criterion: incompetence, misbehavior, inability, what amounts to any of them, and who is to determine that. So the law is not express on that. It just gives you grounds, and that's why we are saying that there may be a big gap.
Chair, a follow-up question, Chairman, sorry. Section 6E of the Administration of Parliament Act, Amendment Act, says role and function of leader of opposition. And these are the ones. One, the principal role of the leader of opposition is to keep the government in check. How do you determine incompetence in respect of that role? And who determines it? Two, the leader of parliament or opposition shall, under subsection, in consultation with his or her party leadership, appoint shadow cabinet for members of the opposition. How do you determine incompetence in view of that? Three, the leader of opposition shall be a member of the Committee of Parliament responsible for determining the scheduling of business in Parliament. Member of the Business Committee. How do you determine incompetence vis-a-vis that? Four, the leader of opposition shall study all policy statements of government with his or her shadow cabinet and give the party's views and opinions on and propose possible alternatives. How do you determine incompetence on that? Would you, since the bill does not, the current bill does not provide other functions other than those in this particular act, would you give us your take on how you determine incompetence in view of these functions? And who determine it?
Yes, on them may be in vain. It is not. It is as you have rightly mentioned, unless there are other functions which are akin to incompetence in view of that function.
Honorable Wilfred, are you saying as the functions in the manner they are coached, it is impossible for the law to be competent? Is that what you are trying to say?
I'm asking the witness, in view of those functions clear in the act, how do you determine incompetence, and best on, and who actually would determine incompetence? For example, keeping government in check. Would you expect members of parliament from, let's say, the NRM to determine that this particular leader of opposition is not keeping us in check?
Because these are procedural aspects which may not be all captured in the substantive law. So if the bill was to go the way it is, definitely it may require regulations to address some of those issues. For instance, if you are going to vote, how is the voting done? Who chairs? What will be the quorum if you are voting? The law cannot address that.
Thank you. Now, where would you want the regulations to be housed? Under this particular act, or the Political Parties and Organizations Act, or the Rules of Procedure of Parliament?
Because it is quite, Parliament shall by law prescribe the following in respect of the leader of opposition. So that means that the procedure, if we are to have this law passed, this bill passed into law, that means the procedure either has to be embedded in this very law, or perhaps the rules of procedure of Parliament. Otherwise, without them being articulated, it may not be easy for you to conduct this election of the leader of opposition.
Yeah, but a party that elected him or her, B, if he or she resigns from that office, C, if he or she leaves the party which elected him or her, D, if he or she ceases to be a member of parliament under Article 83, and then E, if the party which elected him or her ceases to have the position described in 6B. Meaning, at some point, like we have by-elections, there may be a case where another party gets more members and then they lose that position. If you analyze that presentation, it supports the democratization and respects the rule of the majority and the minority. For example, we in the opposition, we have collectively lost power to NRM. In democracy, we are not expected to be complaining, why hasn't President given us also something here? We are being marginalized and etc. Do we have that right? We don't have that right. He chooses because the winner takes it all. So even in the opposition, when we go for elections, we already know either I win or I become second. So if you are a small party and you have not gathered all the numbers, what makes you have that claim? Because that's what you are trying to propose here. What gives DP, what gives JEMA with one member a louder voice and say, I must be taken care of? Yet you had opportunity to compete, and because people rejected you and gave somebody else, now you are hating the other one. Why do you have majority? You give me something. Then address us also that the leader of the opposition is an equivalent leader of government business. So can we also now, in the opposition, make a claim that we are being marginalized in how the leader of government business is selected?
But Honorable Dur, I think from Mchi, there are no winners among losers. You are all losers in the opposition. And you should deal with yourselves as collective losers.
Can we answer questions that you ask?
Okay, thank
These
you.
other experts, you can make a comment. If you don't have an answer, you can.
All right.
Chair, that is okay. At some point, I would request that you move Fox to be a witness so that I can examine him since he wants to answer.
Thank you, Chair. Thank you, Honorable Odru. The last task to get other benchmarks where this has been happening. Chair, we can do this. We are just only limited by time. But if you could permit us, since you're still receiving views by Friday, we can make an additional comparative studies elsewhere and put in our report. Now, some of the issues Honorable Odru raised have been already addressed. However, you raised a very important concern which I talked about earlier. What happens if the party does not consult and raises its nominees? So that is, first of all, consultation, as you really mentioned, currently is not formalized under the law. It may be existing informally, but not formal. And what we are trying to say that if the concern, because when you look at the bill, the complaint being raised is that the minority opposition members of parliament are sidelined, or on ground that the party with the majority is the one to appoint a leader of opposition, and therefore they are complaining that for them they don't participate, away from what Honorable Fox is saying, that you are collective losers as opposed to maybe different losers, if I can put it that way. What I get here from the mover of the bill is trying to suggest that can we as opposition members of parliament deal with our leadership as members of opposition by allowing all of us to come to select who should be our leader, which I pointed on under the negative that is going to weaken political competition, because one of the concern is that you already had a chance to go and compete with others to garner enough representation, so that one gives you a better standing. So when you go, you get 2 members in a party, the other party gets 100 members, then you the 2, for instance, want to determine, you want to be the leader of opposition, even leading the party which has majority. What? Somehow it loses this aspect of political competition, and the parties will even cease to have a reason why they should have enough representation, as opposed to merely having anybody to represent them in parliament. So that's what I know, that this weakens political competition and the core basis of the multi-party dispensation. And that's what I say, that in that respect, the bill has challenges. And also, the aspect of marginalization, I think when you look at the bill, it does not necessarily mention marginalization. The mover is trying to complain that we are sidelined because we are few. Perhaps which you can say is marginalization. Because we are few, we are sidelined. But as you rightly mentioned, what about a ruling government which is taking decision without anybody complaining? Can we also go and complain that after all we also won, notwithstanding you are the ones in power, we have to determine what you do? That ceases to be a democratic system of governance. So that's what we said in our documentation, that to that level, we didn't get clear what the mover wanted. Is it that when a political party with a majority representation appoints a leader of opposition and the other political parties with the minority have not participated, is that the problem? Or the problem is because the minority are not represented on what we term as lead of opposition, so they feel discriminated? That is not clear. And that's why I'm saying that the move of the bill has not concretized the problem, because the problem would be the parties are not represented in terms of leadership. Here we have a leader of opposition who comes from the political party with the majority members of parliament, and that is what multi-party dispensation is all what about. So his concern is not very clear, and I think that's why some are drawing conclusion that the bill might be in bad faith, not in good faith. Then Honorable Werike, that's the name, Honorable? Yes, Honorable Werike.
Before you go to the next, I don't know if you noted it down, conflict between some countries in the Middle East, and they've aligned themselves between Russia and Ukraine, for example. And we know that the UK and the US are siding with Ukraine. So would you then force Russia and say, you go and consult the UK on how to handle this war, when you know very well that they're already on that side and I am bringing it here? Would you force a leading opposition party like NU to go and consult other parties that they already know are already working with the people they are supposed to check, or even to vote, to influence their decision? Would it make democratic sense? Would it be development of our laws? That's why I said I hold LDC at a very high level. Would it support the development of our legal system, our multi-party dispensation?
Opposition parties, as they elect their leadership, other than, for instance, leader of opposition, even leader of opposition, consultation is a good practice. However, we cannot confine the determination of the leader on the outcome of the consultation. We cannot use that benchmark. In my view, the party with the majority leadership, that one should take the day. However, it should engage other minorities.
So, just the last one. Let me now put this under 2. It says, in electing the leader of the opposition, the party to which he or she belongs may consult other political parties in opposition to the government and the independent members of parliament.
I think the challenge has been the use of word may there, meaning you can consult, you may not, unless it is interpreted to mean mandatory.
And that is the point I'm driving to. If already I know that these other political parties in opposition have already chosen to be on the other side, then I should have the discretion to choose whom I consult. Because if you condition me and then the other party is already on the other side, you are tying my hands to work with, let's say, people who are opposed to me. So for me, I think the construction here was deliberate, where there's a coalition on the side of the opposition and then there's also a coalition on the side of NRM. Then I should delete from consultation those ones who are already on the other side. And that's why I think this provision, as it is, may actually be more sufficient and elaborate than conditioning a political party to work with the other side. Just like we cannot tell NRM in choosing the Prime Minister. But we may say in choosing the Prime Minister, the President may consult with opposition. But you cannot say shall consult with the opposition, even cabinet.
Lastly, Chair, we were asked, the economy is that, one, we are saying that the Kenyan model, which provides for a lead of opposition from majority and also minority. Minority, which Honorable Odu clarified that is the second, that is the minority. To us would be a better test, but not taking away the powers of the party that has garnered majority votes to determine or a leader of opposition. They can just consult with the minority to determine, such that the roles of a leader of opposition are left intact and can be achieved. Otherwise, we may have a situation where a leader of opposition cannot perform his or her roles effectively. Because if we go into this system of voting, casting vote, we are like the sabotage I talked about earlier, the political influence is a result of having a leader of opposition who is not opposition in spirit. And in terms of executing the duties as per the law, it becomes completely hard. Therefore, we lose fact on that. So that would our view. We are going.
Do you mind now in making your final harmonization? Also look at, because it looks like I do not look at the Administration of Parliament Amendment Act, and two, presentation on the Kenyan model, so that you come out clearly and unambiguously as lawyers, Mr. Muchibi.
Paul Muchibi nga nkulira kitongole ekikola ku by'okunoonyereza okuripotinga emisango n'okulongoosa okola ennongosereza mu mateeka ku Law Development Center nga tukiikiridde Director we LDC wano. Ekisooka kya byonna ebbago lino nga bwe liyimiridde olwaleero, omulamwa gwali omutuufu teguvaayo, gutawaanya okutegeera. Okwemulugunya aleeta ebbago kwalina nti nga ba memba ba parliament ab'oludda oluvuganya gavumenti opposition tebeetaba bonna mu kulonda omukulembeze waabwe. Ekyo kyeyemulugunye nnyo, kyagamba nti baali badde baweebwa omukisa ne balonda, n'atalondebwa kibiina ekisinza ababaka obungi ku ludda oluvuganya. Ekirina okutegeerebwa ennyo bannayuganda, ekisooka kiri kimu. Olwaleero amateeka ge tuliko ga nkola ya bibiina ebingi, multi-party political system. Multi-party political system abaamu okuvuganya. Okuvuganya kuvaamu omuwanguzi n'awanguddwa. Kati bw'oba owanguddwa tosobola kujja ne weemulugunya nti gw'awangudde nange nina okusalirawo ku ky'olina okukola. Olwaleero gavumenti webeeronda akulira emirimu gyayo mu parliament, leader of government business, teyeebuuza temala kwebuuza ku buli member of parliament akiikirira gavumenti oba akiikirira NRM. Era bw'eba eyagadde esobola okwebuuza naye si tteeka nti eteekeddwa okukola ki? Okubuuza. Kijja kunafuya nnyo etteeka oba enkola y'ebibiina ebingi. Singa ebibiina bigenda mu kalulu, ekibiina ekimu ne kifuna obululu obungi, obululu 100, ekirala ne kifuna obululu 2. Eky'obululu 2 ne kireeta akulira oludda oluvuganya ki? Parliament. Ate ng'ekireese abantu ababaka 10 tekifunye muki? Mukulembeze oyo. N'ekibiina ekyo kyennyini tekirina buyinza bulonda akulembera. Tuba twonoonye enkola y'ebibiina ebingi, enkola y'okuvuganya mu by'obufuzi. So etteeka erireetebwa ebbago, omulamu ogwo teguvaayo bulungi. Era oyinza okugamba embeera oba kye tuyita spirit mwe lyajjidde si nnuŋŋamu oba bad spirit, teriraga mulamwa muki? Mutuufu. Olwaleero etteeka ligamba nti ekibiina ekisinga ababaka abangi kijja kulonda leader of opposition ate kisobola okwebuuza ku bibiina ebirala bekiri nabo. Olwaleero enkola y'ebibiina mu Uganda etabuse. Tulina abali mu opposition ate nga bali ne muki ne mu gavumenti enfuga. Kati olwaleero abali mu side eno n'eri olwo nabo bajja kulonda. Okuteekawo okulonda ani akulira opposition. Kitegeeza nti n'abagamba nti opposition ate the same time nga bali mu gavumenti ekola ki efuga nga babaka ba parliament abo nabo bagenda kulonda. Bw'otegendereza baba bangi ojja kufuna leader opposition atali opposition ate nga obuvunaanyizibwa obuweebwa leader opposition mu tteeka alina okucekinga government, alina okuteeka government ku nninga buli kyekola. Ojja kufuna omukulembeze atasobola kuteeka government ku nninga. N'olwekyo tugamba nti etteeka eririwo terina buzibu. Ekiyinza okwogerwako kyokka nti ono ekibiina ekisinza ababaka kisobola okukolagana n'ab'ebibiina abiki abalala, naye enkolagana terina kubeera ate ya mpaka nti bwe kiba tekikwataganye nabo olwo kye basazeewo kiganye. Ekibiina kiri ekisinga abantu kiina advantage nti kyasinga ababaka era kirina okukola decision ekola ki esembayo. N'olwekyo tugamba nti ne Kenya bwe kiri, so tekiri wano wokka Uganda. So etteeka lino ebbaga erijja okulongoosa mu tteeka omulamwa gwalwo omutuufu tegulabika kubanga ekiriwo olwaleero tekirina buzibu. Bw'oba oyagala kujjako leader wa opposition eyo ng'ensonga emu ebadde eweereddwa mu tteeka tosobola omuggyako olw'okuba nti tatuukiriza buvunaanyizibwa, yeeyisizza bubi oba takola buvunaanyizibwa bwe. Bw'otunuulira obuvunaanyizibwa obuweebwa leader opposition mu tteeka buli kiriya nnyo. Tolina bw'ogenda kusalirawo incompetence eyogerwako misbehavior, tolina bw'ogenda kirambulula. Wabula embeera entuufu erina okutambula nti leader of opposition waba wakugibwako ekibiina ekimusindika kirina obuyinza obwo era kyo kimala kutuula mu sisitemu yaakyo lwaki kijjako omuntu oyo nekisalawo. Naye tunakiteeka mu tteeka ng'etteeka teriwa parameters ate nga ebibiina bijjudde mu side evuganya ne side efuga naye eriyo ab'ebibiina olwo multi party system eba egenda kukola ki kufiira ddala.